Hello, this is Professor Harper, and today we'll be talking about defamation. And what there are a number of definitions of defamation, and you know, defamation is a communication that exposes a person to hatred, ridicule, or contempt, lowers him in the esteem of his fellows, causes him to be shunned, or injures him in his business or calling. The Associated Press Style Book warns that probably 95 out of 100 libel suits arise from run-of-the-mill stories, and most of these lawsuits are basically caused by carelessness. One case that I was involved in as an expert witness was a Pennsylvania newspaper had a story about a woman who was charged with being an accomplice after the fact in a murder. The problem is that the newspaper got the name of the woman wrong. The person who was charged was the daughter, and the woman sued for libel and sued successfully because of an error and also the newspaper's reluctance to correct the story. There's libel per quote, which basically means that these are libels that are not readily apparent. Okay? They're only libelous because of context or unrevealed circumstances. So he is perfectly healthy is not libelous unless the individual is collecting disability benefits and suspected of defrauding his insurance company. A wedding announcement would not ordinarily be defamatory unless it's a practical joke on two people who hate one another. A mention of her pregnancy would not likely be defamatory unless the undisclosed facts are that she is a nun. Mostly what we're talking about, though, is libel per se. Libel per se applies to statements that are defamatory on their face. By their very nature, they could cause damage to the reputation of any person. Charges or claims that a person has committed a crime, statements disparaging a person's competence in her business profession, statements asserting or implying that a person has a contagious or offensive loathsome disease, and charges or claims concerning an individual's personal habits, character, especially when it comes to sexual immorality. The elements of libel are fairly straightforward. Okay, first of all, something has to be published or broadcast. Secondly, the person who says he or she is being libeled must be identified, although it doesn't necessarily mean by name. I was involved in a case where the individual was identified as the owner of a store. Everybody in the city knew who owned that store, so even though the individual was not named, the person sued successfully for libel. The third part of the defamation is that it's more than simply being false. Okay, the statement must carry some weight or sting that would damage a person's reputation, hurt his business, or cause his or her friends and associates to shun her. Okay, there also must be injury or harm. Plaintiffs who cannot prove actual malice must show that they suffered some kind of damage, such as personal humiliation, mental anguish, or financial loss. Now, there are various types of damages in a libel case. There are actual or special damages, and these are lost wages, lost revenue, out-of-pocket costs, and this isn't going to be a lot of money. There are general damages that are provable but intangible, such as shame, humiliation, loss of good name, and mental stress. And then there are what are called punitive damages. This is where the big money is. Plaintiffs who can show actual malice may also sue for punitive damages that go beyond compensating the plaintiff for injury and are intended to punish the defendant for the libel. So we had a case recently which was an invasion of privacy case, but close to libel. Oftentimes invasion of privacy and libel are charged at the same time. So Hulk Hogan, the wrestler, sued Gawker for showing a video of him having sex with his friend's wife. And Gawker was found to be guilty of invading his privacy, and he won damages in punitive damages of $115 million, which is likely to make Gawker go out of business, which in my view is not a bad thing. So fault is important in a libel case, so that the plaintiff, or the one bringing the lawsuit, must prove some degree of fault on the part of the defendant. Okay? The defendant must have acted in a careless or irresponsible manner that resulted in the injury. And here's where we go into different classes. So there's a higher standard for public officials and public figures, which is actual malice. That means that we recklessly disregarded the truth. So we gave evidence as the plaintiff to the defendant, the news organization, and the news organization disregarded that. For private persons, it's negligent. And here it involves matters of public concern for actual malice. Okay? And again, actual malice is necessary to get into the issue of punitive damages and seek severe punishment against a news organization. Now, the defense that you can take as a news organization is that what you say is true. You can also say that it's fair comment and criticism. So you can do a bad review of a restaurant or a play, and you cannot be charged with libel because you are making a comment. There's something called fair report, or reporter's privilege, which basically means that if a police officer, an officer of the court, announced that Christopher Harper had been indicted for murder, and then I win at trial and I'm found to be innocent of that charge, you can't charge or maintain that the news organization has committed libel because a public official said that that was in fact the truth at that time. There's a constitutional defense called absence of malice, that I did not intentionally go out to give you a bad name. There's consent. It basically means that I have agreed to do something. There's also a statute of limitations in most libel cases. It's usually a year. Keep in mind also that most libel cases are in state courts. They are civil trials, although there are times when a case can be heard in a federal court. It's usually when the plaintiff, or the one bringing the lawsuit, and the defendant don't come from the same states. Okay? A retraction is not actually a defense, but might serve to mitigate the damages. So a correction is always a good idea if you make a mistake. There are other issues that are involved, and these involve neutral reportage. Is the reporting all sides of a story an accepted common libel defense? And generally it is. There are limited public figures, so that it provides a higher standard if someone is known to the public because you are a witness to a crime, for example. Okay? Fabricated quotations. Is it always reckless to change a direct quote? It is, but not necessarily under the law to successfully sue for libel. And when it comes to the issue of fact versus opinion, opinion and parody, making fun of someone, usually gets you off. Okay? So that if you misstate a fact in order to support an opinion, that doesn't necessarily mean that you're guilty of libel. As I said, fiction, humor, satire, it only can be libelous if it's reasonably understood to be factual. There's a case where Hustler magazine did a parody of the Reverend Jerry Falwell, and no reasonable person would believe that he had sex with his mother. Okay, that's what the opinion was about. And there are some problems when it comes to liability on the internet. So the internet provider, Verizon, Comcast, are not liable for libel because they're simply, like the telephone companies, they're simply passing the information through. Now there are risks when it comes to cyberspace for a web publisher. Essentially, the same laws apply to what's written on the website, but you can also find some problems when it gets into the comments area, and that's particularly true if the news organization edits those comments. So, what's the impact of libel litigation? Oftentimes what happens is that there's a chilling effect when more and more libel cases are filed. People in the news organization costs a lot of money for libel insurance. If you don't have libel insurance, it's going to cost you a lot of money simply to defend yourself, okay? Because even if you win, you still have to pay for the court costs and your lawyer's costs, unless it's determined by the jury or the judge that the bringing of the libel suit was wrong in the first place. Now, the courts do distinguish between public figures and limited public figures, and here the rule is if somebody holds a government office, is a police officer, works for the city or state, or is someone who's prominent in a community. These are generally public figures, where limited public figures are people who ordinarily, or private individuals, but for some reason, whether they are involved in seeing a crime or they are considered limited public figures. Now there are some important cases, New York Times versus Sullivan, where Mr. Sullivan was sued for libel against the New York Times because the New York Times published an advertisement that essentially chastised and criticized the police in Montgomery, Alabama for the way that it dealt with African Americans during civil rights. Mr. Sullivan was on the city council. He was in charge of the police during this time, and the courts in Alabama found for Mr. Sullivan. However, the Supreme Court said you needed to prove that the New York Times was actually malicious towards Mr. Sullivan rather than simply providing information, because otherwise any criticism of government or civic affairs would be limited if the news organization had to prove that everything that was printed was factually accurate. Curtis Publishing v. Butts extended it to public figures. Curtis Publishing, which was the Saturday Evening Post based in Philadelphia, did a story about two prominent football coaches in college football involved in illegal gambling. The story was absolutely wrong, but the ruling did say that there had to be a higher standard because these individuals, entertainers and people of prominence, could call a news conference, go before a news conference, and make their case. Okay. Herbert v. Landau involved 60 Minutes, and here it allowed people seeking damages to determine the state of mind or what the biases were of a 60-minute producer in producing a piece.